We begin with the presentation of Professor Paul Nemitz on EU Justice Scoreboard as continuation of his presentation in the first session. Professor Paul Nemitz, please.
Efficiency, quality, and independence are the three aims of the annual Justice Scoreboard exercise the European Commission carries out with the member states of the European Union. These three factors are important not only for reasons of the rule of law and bringing it to function through an independent and well-functioning judiciary, but they are also important for economic reasons. Improving efficiency, quality, and independence of national justice systems continues therefore to feature among the priorities of the European semester, the EU's annual cycle of economic policy coordination. The 2021 annual sustainable growth strategy of the European Union, which sets out the economic and employment policy priorities for the EU, reiterates the link between effective justice systems and the business environment in member states. Well-functioning and fully independent justice systems can have a positive impact on investment and therefore contribute to productivity and competitiveness. They are also important for ensuring effective cross-border enforcement of contracts and administrative decisions and dispute resolution, which are essential for the functioning of the single market and any economy. The economic relevance of an independent, well-functioning judiciary has been documented in many different contexts, and in my written contribution I refer to some of those important sources. When we look at the efficiency of the systems, we look basically at three indicators, namely the length of first instance court proceedings, the length of proceedings in all court instances, and the clearance rate. In the broad all cases and in the litigious civil and commercial case categories, the overall number of member states where the clearance rate is more than 100% has increased since 2012. In 2019, the majority of all member states, including most of those facing challenges, reported a high clearance rate, more than 97%, which means that the courts are generally able to deal with the incoming cases in these categories. And there has also been a continuing progress on the backlogs regarding all categories of cases. When we look at the quality of the justice system, we look at four indicators, namely the accessibility of justice for citizens and business, adequate financial and human resources. We need assessment tools be put in place for self-control of the judiciary and self-assessment, but also for assessment by the political authorities and the justice ministries. And we have looked for the first time also more intensely at digitalization. Accessibility issues like court fees and the level of legal aid have an important impact on justice, and our member states have made progress in this area over the last years. But there are also issues such as the court fees, which have remained largely stable, but nevertheless some member states have raised even court fees for low value claims. The difficulty in benefiting from legal aid combined with high level of court fees in some member states could have a dissuasive effect for people in poverty to access justice. Then, as to the resources, high quality of resources is key for a functioning judiciary, including the necessary investments in physical and technical infrastructure, appropriate initial and continuous training, as well as the diversity among judges, including the gender balance. The 2021 EU Justice Scoreboard shows, in terms of financial resources, the data show that overall in 2019, general government total expenditure on law courts continued to remain stable, with significant differences in actual growth, both in euro per inhabitant as also in relation to percentage per GDP between member states. Almost all member states increased their expenditure per capita in 2019, and a majority also increased their percentage of expenditure related to GDP. As in 2020, the 2021 scoreboard also shows the breakdown of total expenditure into different categories based on data gathered by our statistical office, Eurostat. Women still represent less than 50% of judges at the level of Supreme Courts in most member states. The evolution over a 3-year period from 2018 to 2020 shows that trends diverge between member states, but the proportion of female judges as Supreme Courts has risen since 2010 in most member states. On the training of judges, while almost all member states provide at least some continuous training, few offer training on ICT skills, court management, and judicial ethics. And we consider these areas to be very important. The use of surveys among court users and the legal profession was slightly higher, and now we are in the area of assessment tools, in 2019 than in the preceding years, with a stable number of member states opting not to conduct any surveys. However, there seems to be some variance as to which member states did not conduct surveys, indicating that surveys are sometimes conducted only every second or third year. Accessibility, customer service, court hearing quality, judgments, as well as the overall trust in the justice system remain recurring topics for surveys, but only a few member states inquired about the satisfaction of groups with special needs or about individual awareness of their rights. As to digitalization, the edition of 2021 of the Justice Scoreboard now includes an extended component examining in detail aspects of digitalization of justice. Although most member states already use some kinds of digital solutions, mainly office automation, honestly not a big deal, there is thus a scope for improvement. Almost all member states now provide access to some online information about their judicial system. Less than half of the member states have digital-ready produced procedural rules, which allow for use of distance communication and for admissibility of evidence in digital format only. So on the judicial use of digitalization, like the legal profession generally, we are behind, and there is certainly scope for increasing productivity through increased digitalization. Quality, efficiency, and independence, and the scoreboard also looks at the independence as the factual basis for the rule of law report, in particular at the external independence, namely the need that the body concerned the court exercises its function, or the individual judge, autonomously without being subject to any hierarchical constraints or subordinated to any other body, and without taking orders or instructions from any source whatsoever, thus being protected against external intervention or pressure liable to impair the independent judgment. And internal independence and impartiality is necessary, namely when an equal distance is maintained from the parties to the proceedings and their respective interests with regard to the subject matter of the proceedings. We differentiate between perceived independence, reflecting input from many different bodies dealing with courts and professional associations, and we look at structural independence. European standards have been developed by the Council of Europe, for example, the 2010 Council of Europe recommendations on judges, independence, efficiency, and responsibility. And we work very closely with the Council of Europe on these issues. The figures provided in the scoreboard do not provide an assessment or present quantitative data on the effectiveness of safeguards regarding to independence. They are not intended to reflect the complexity and details of the procedures and accompanying safeguards. It should also be noted that implementing policies and practice to promote integrity and prevent corruption within the judiciary are essential to guarantee judicial independence. Ultimately, the effective protection of judicial independence also requires a culture of integrity and impartiality shared by magistrates and respected by the wider society. And the recent judgment concerning Romania of 21st of December of the Court of Justice is a warning to all of us that independence can even these days also be put in question by the way higher judges deal with lower courts. And we have seen similar developments also in Poland. So to conclude, the European Union has moved from an economic union to a union of fundamental rights, democracy, and the rule of law. It has developed a variety of legal, political, and economic instruments to ensure that member states comply with these principles laid down in the treaties and the Charter of Fundamental Rights. The annual rule of law reports and the annual judiciary scoreboards by the European Commission and the related political conclusions in the Council and the European Parliament are not only flagships of an emerging common quest of the Union and its member states for highest standards as regards independence, quality, and efficiency of justice. They also demonstrate the importance of democracy and legal systems defending their integrity and good functioning. The Rule of Law report and the Judiciary Scoreboard, their accompanying measures, the technical support provided, for example, by the Commission, as well as the actions taken on their basis by member states, represent important financial, intellectual, and political investments. These investments are vital in times in which even the highest courts in some countries are being instrumentalized by executives which aim to do away with any type of checks and balances, whether external or internal, whether by courts, by the press, by civil society, or by parliaments. And we have seen some of this in Poland and Hungary, in Europe in particular. And these attacks on judicial independence, on the rule of law, and on democracy require a firm response of all who stand for justice and democracy, whether as individuals or institutions. Thank you very much.
Many thanks, Professor Paul Nemitz, for your presentation.